Kenyatta Stevenson versus the City of Doraville et al., case number S12G1316.
Marcus Howard for appellant, Harvey Gray for appellee.
May it please the Court. My name is Mark Howard, and I represent Ken Stevenson in this case. This case presents an opportunity for this Court to clarify some unanswered questions regarding the public duty doctrine, which is a doctrine that this Court created in 1993 in the Jordan versus City of Rome case. And what that doctrine essentially provides is that a government entity is not under a duty to provide police protective services unless, to the general public, unless there is what's called a special relationship between the municipality and the victim. However, the cases have left open some unanswered questions about when liability may also be present. Number one, can liability be present if there's actually negligence on the part of a police officer that causes or contributes to an injury? And number two, are there circumstances outside the, quote, special relationship where there is a special duty or a separate duty to render assistance when there is an identifiable individual who is known to be in harm's way and where the officer has time and opportunity to render aid? Now, before I get into...
Well, implicit in your statement is, maybe I'm just reading it in, but implicit in your statement is the Court of Appeals did not change the law.
What we're saying, Your Honor, is that the Court of Appeals did not change the law, but they applied the law, public duty doctrine, more broadly than we have ever seen it applied before. Specifically, in our case, there's expert testimony that there was negligence on the part of the officer. There's testimony by witnesses that there was active negligence. And we think in the Court of Appeals' opinion totally failed to address the sequence of events that led to this. And I actually have some demonstrative evidence I'd like to show the Court that might illustrate the point I'm trying to make. First, this is simply for demonstrative purposes. It's not a to scale drawing, but this is a Google Earth view of 285 where this incident occurred. And what the Court will know from the briefs is that my client, Ken Stevenson, was traveling on 285 near Doraville, was stranded in the middle lane of traffic, lane number 3, and I've marked his vehicle with an S for Stevenson in the third lane. As he was coasting to a stop, he saw Officer Sean Mahar of the Doraville Police Department, that I've marked with an M, turn on his blue lights. Then, for about 5 minutes, my client called up his brother and said, "There's a police officer here. His lights are on. I feel better. I'm going to wait for him to render assistance." And after time kept going on, my client said, I don't know what's happening. He got out of his vehicle to wave to the police officer and stood in front. At this time, there was a cluster of vehicles coming up from behind. And first, I would like to say that the placement of Officer Mahar's vehicle in the first lane was determined by the investigating police officer after the scene, Travis Bowie. His affidavit's in the record. And he says that he determined Officer Mahar was in the first lane of travel. Next, a cluster of vehicles was coming up behind.
So just to be clear, he's not on the shoulder?
Correct, Your Honor.
He's actually in a lane of...
He's in the lane.
Correct, Your Honor. And that is Travis Bowie's affidavit. It's in the incident report, and we went and obtained Officer Bowie's affidavit, and we said, "Is your incident report correct? Are you standing by your testimony?" And he said, "Yes, I am," and he signed an affidavit to that effect.
Counsel, was the state move-over law in effect at this time?
Yes, Your Honor. The state move-over law, I believe, was in effect. And at this time, as we have here a vehicle marked with a Z, which is James Zastro. He was a motorist who was in the second lane of travel. His testimony is that a tractor-trailer, and I've marked it with a question mark because we just don't know who was driving that, pulled over from the first lane into the second lane, which I've marked with an arrow. Because of the spray that this tractor-trailer sent up into Mr. Zastro's windshield, he then pulled into the third lane of travel and collided with my client. Coming up behind, finally, is Arnold Sloan, whose affidavit is also in the record. He said he had been in the second lane of travel for several miles, and he came on the collision right after it happened, couldn't avoid it, and went into the median wall. If any of you are driving out there today, you can still see the chunk of wall where this occurred. What The key facts that we take from this diagram are that, and from the affidavit testimony and depositions, is that Officer Mahar was only 50 feet away from my client in the 5 o'clock position in the first lane of travel. Officer Mahar turned on his police lights while my client was still moving. Now, Officer Mahar denies this, but my client says, yes, I saw the lights come on when I was still moving. And we contend that this is evidence to show that Officer Mahar knew the vehicle was occupied. Officer Mahar sat in the first lane of traffic with the lights on. That's Travis Bowie, Officer Bowie's testimony. Officer Mahar did nothing for 5 minutes. Now, this is a big point in the case because there's a transcript, a radio transcript, and Officer Mahar's testimony says, oh, this all took place so incredibly fast I couldn't do anything. And I'm sure at trial, if we're allowed to go to trial, that's going to be something that they hammer on. But this is summary judgment, and the testimony here from other witnesses is that 5 minutes passed. So we contend there was time to take action. Next, my client testified that he did not take action in this case based on the blue lights, that he relaxed when he saw the blue lights behind him. When Officer Mahar finally called into the radio to the dispatcher 5 minutes later, he did not say there was an abandoned vehicle. He said we need to assist motorists. That contradicts Officer Mahar's testimony that he thought the vehicle was abandoned. Next, traffic diverted to the middle lanes out of the first lane of travel where Officer Mahar was. And finally, there was a collision and injury. Now, the next exhibit I'd like to show you is the stretch of road that's involved here. And this is a Google Earth version of a view of the stretch of roadway. Now, Officer Mahar has said, you know what, I was not in the first lane of travel, and I was separated by a grassy gore area on an entrance ramp right here. So in other words, Officer Mahar says he was here, and that my client was here, that he wasn't blocking traffic, and that he couldn't get over because of this grassy gore area. However, he's the only witness in this entire case who has testified that that's where the incident occurred. Every other witness in the case has testified that this occurred here, that Officer Mahar was in the first lane of travel, and that my client was here. This is a quarter-mile away from the entrance ramp. And 2 other police officers have testified that that's where the collision occurred. All the eyewitnesses have testified that that's where the collision occurred. And we think a jury would find that compelling, especially because there's a missing videotape in this case that would have shown exactly the position of the vehicles. In addition, Officer Mahar, after this incident, had to resign from the Doraville Police Department for falsifying evidence. We believe his credibility is something that a jury would find, he would not be a compelling witness, let's put it that way. And we've
You're on summary judgment, right?
Your Honor.
So all you need is any evidence going your way. Can I ask, putting aside, or going to the active negligence issue for a second, if a private individual had seen this stall and put their car in the same position as the officer and put on their emergency lights in the first lane of traffic, causing other cars to divert, do you think that would be a just generalized tort? Would you be able to make out a case against that driver?
Yes, Your Honor, and I think if we could show that there was a violation of some standard of care or of ordinary negligence, if someone testified that this motorist parked his vehicle with his lights on in the first lane of travel and caused me to move over and cause a collision, yes, I think that that private individual could be held liable. In addition, though, because this is a police officer and we have an expert who said that we have an expert who has testified about the way the motoring public responds to blue lights and has said that because this officer was parked there with his blue lights on, of course that caused traffic to move over to the center lanes. That's just the way it happens, especially with the move-over law. And so in this case, not only is there a duty like there would be for a private individual not to commit active negligence, but there was also a duty to act. And I will say the Court of Appeals opinion was totally silent on the issue of the traffic diverting over to the center lanes, didn't mention it at all.
Mr. Howard, specifically, where do you say, usually I've seen the public duty doctrine when you're talking about a third party involved. This is directly against. How do you get to that stage?
Yes, Your Honor.
And secondly, specifically, what do you say were the acts of the officer that bring in the public duty doctrine?
Okay, I'll try and answer that in 3 ways.
Thank you.
Number one, this is not just an act of a third party, it is the act of the officer. And so we have first party liability here. And the ways we say he was negligent was, number one, being in the first lane of travel and a semi coming out of the first lane of travel where he was, having his lights on, which everyone knows tells you to move over. So those are active parts of negligence that actually contributed to the chain of events. Next, he failed to render aid to an identifiable individual who was known to be in peril. The officer admitted that this was absolutely foreseeable that he could be injured, and where he had the time to act. The 5-minute period is critical here. Officer Mahar, and I'll even show you right here, Officer Mahar admitted on page 46 of his deposition that it would have taken him less than a minute to get over, and my client's brother testified that 5 minutes passed while he was on the phone with his brother.
Let me ask on that. This court's never recognized that exception to the public duty doctrine. I mean, a justice here, a justice there has suggested they might recognize it, but a majority of the court and the Court of Appeals have never actually recognized that exception. Right?
Just so I'm clear, are you asking about the act of negligence
No,
exception?
no,
or
the fails to render aid to an identifiable victim.
You're absolutely right, Your Honor. This court has never said that. However, in the Jordan case, in footnote 2, the court said we're specifically dealing with an act of nonfeasance, not an act of malfeasance. The court in Jordan also, in that case, interestingly, said that there was an allegation that there was negligent training by the 911 officers, but the plaintiff, for some reason in that case, never provided expert affidavit testimony. We've done that in this case. We actually have an expert saying this person committed negligence. Now back to Justice Hines' question about third parties.
Before you move on to the third exception, on this one, if we were to recognize this duty, it would mean that every time an officer responds to a traffic accident or anything, a 911 call, and sees a victim, that they have an affirmative duty under tort law, so no negligence to provide aid. That would be very different than anything a private party would have, right?
Not necessarily, Your Honor, and I'll try and answer it this way. Certain professions, if we're talking about the duty to render aid, certain professions have standards of care and written policies. For example, let's say this were a medical malpractice case, and there was a written policy at a hospital, or an expert came into court and said they violated a standard of care, then there could be a negligence action against that doctor by virtue of their profession. Here, we have, for instance, here's the code of conduct for the City of Doraville, which says no officer shall fail to render aid, assist, or protect a fellow officer or citizen to the fullest extent of his or her professional capabilities in time of need. So there's actually a code of conduct. We also have expert testimony, which says that Officer Mahar was negligent in 4 ways. One, by placing his vehicle behind Mr. Stevenson's vehicle, engaging his police lights in the 4 or 5 o'clock position, violating the written policies.
But this wouldn't be based, I mean, this wouldn't allow, well, any police, if we adopt this duty, any police department in their right mind would never have such a policy because it would be triggered by the policy. If we adopt the policy, I mean, if we adopt this exception, it applies whether or not there's any written policy. Every police department, every law enforcement in Georgia will have this duty that anytime they respond and see an identifiable victim of a traffic accident, a crime, then, and whatever it means to have enough time and resources to respond. Apparently, they always have time and resources. They show up and have the time to be there and the body to send there.
I think that would be a fact question, but there would in fact be a duty. If we are asking the court to hold that there is a duty to render aid, but it does depend on the specific circumstances, and we are asking it to be limited to first, acts of negligence, obviously, but then secondly, if it's an identifiable person, if they are known to be in harm's way, and where the officer has the means and knowledge and opportunity to act, as they did in this case. As for the third party, back to Justice Hines' question about third party liability, the case law, as I read it, says that third party liability deals with, it's hard to predict the acts of people out in the public and how they might respond. In this particular case, we have an expert who has said, look, I know the way the motoring public responds to blue lights on the side of the road, and it is very predictable that if you put a police vehicle with blue lights on in the first lane, that someone will move to the center lane and traffic would be diverted. So unlike the typical third-party situation where you're saying, gosh, I don't know how this third party will react, in this case, it was very predictable that the officer doing what he did here would likely be cause an accident.
Although not predictable enough for an accident to happen the first 5 minutes.
Yes, and that's just, you can't always predict, the exact way vehicles are going to react all the time, but more likely than not, something like this would happen, and in fact, it did happen in this case. I'm
sorry, to go back to that point about expanding the duty. So every domestic dispute where two officers show up at a domestic dispute, they see an identifiable victim, and while they're trying to diffuse the situation, the husband shoots the wife, can turn into a negligence suit with horrible facts, saying the officer was negligent in not disarming the husband and not tasering the husband. And if it's a municipality, there's no sovereign immunity, right, for that? If they have insurance?
If they have insurance, there would be no immunity, yes.
Okay, so no immunity. So every domestic dispute where something horrible happens can turn into a negligence action with really bad facts. I mean, that seems a troubling duty to impose for the first time on every police officer.
Well, there already is a duty in the special relationship context where there is a representation that help is on the way, that the person relies on that, and where there's someone who is known to be in harm's way. In this case, I don't know in the domestic situation if someone is relying on what the police officer said. For example, if the police officer in the domestic situation said, told one of the spouses, hey, don't do something because I'm here and I'm here to help and I'm going to protect you, and then they didn't do something to help themselves and then they were hurt later, that could conceivably be a situation where they would be liable. I think it's very much a fact-intensive situation. And in this case, we have here two separate things going on. One is this officer actually helped cause the accident, and number two, there was an identifiable person in harm's way who the officer had the means, time, and opportunity to assist. I see I only have 3 minutes left, so I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel. Mr. Gray?
Thank you. May it please the court, Harvey Gray on behalf of the city of Duluth. Before dealing with what seemed like a jury presentation of a negligence case, I'd like to deal with the applicable law. I have read every case in the Court of Appeals, of which there are many, involving the public duty doctrine, and I have read the 5 cases decided by this court innumerable times. And I think it's fair to say that based on the majority decisions and the concurring decisions and some of the dissenting decisions, there is a divergence of opinion within the court regarding application of the doctrine. But I would submit that in the context of this case, there is no such divergence of opinion. The city of Rome established and adopted the public duty doctrine, which is the majority rule in this country, remains the majority rule in this country. It is simply, in many ways, a restatement of the restatement of tort section 315, which provides that no one has a duty to render aid to anyone. And unless there is a special relationship. It is also consistent with the Supreme Court decisions under the 14th Amendment. Many of you probably know the DeShaney versus Winnebago case, in which a young child was given back to the custody of his father despite major concerns about the father's violent propensities injured the kid. And they said in the absence of a special relationship, the duty runs to everyone. The police have a duty to protect the public. They do not have a duty to protect any specific individual unless there is a special relationship. And the contours of that special relationship are set forth in the city of Rome, and there is an exception to it. There is one exception to it, and it is the only exception that has ever been adopted by this court. It is the special relationship test. It requires an explicit assurance of police protection that is provided to a person who relies upon that to his detriment. And that does not exist in this case, as found by the trial court and the Court of Appeals. Mr. Stevenson did not say, I saw the officer turn on his lights as I was coming to a stop. He said, as I was coming to a stop, I saw a vehicle off to my right. I did not know if it was in the emergency lane or in the entrance ramp to the expressway. And I assumed it might be a police officer. And I could not get my car over to the side of the roadway because it was 10 o'clock at night on Interstate 285. It was raining, it was dark, and the traffic was incredibly congested. He said cars were going by him, honking their horns, etc. There is no evidence, none whatsoever, that anybody changed lanes in response to Officer Mahar's presence. In fact, the two individuals that he referenced from whom gave affidavits testified unequivocally they never saw any lights of any police vehicle. They never changed lanes in response to that. And as correctly decided by Judge Purdom, the move-over law gives an individual the right. He doesn't have to move over. He can move over, and it says move over if it's safe to do so. What we're talking about here is the potential for a new exception, as Judge Nahamis was talking about, a new exception to the public duty doctrine. In City of Rome, footnote 4 says...
Before you get there, let me ask you, are you disputing whether the lights were actually activated?
The lights were activated. Officer Mahar is a canine officer. These were not blue flashing lights on the top of his vehicle. He had interior lights, and the window was tinted because he was a canine officer for purposes of the dog.
What kind of lights were flashing?
Interior lights. There's a panel of interior lights. What he did...
But they're blue, right?
Huh?
They're blue lights?
They're potentially blue in color. I don't think you could see them as blue necessarily through the windshield. That issue was never really developed. He was on patrol heading westbound on 285. He passed his jurisdiction. He was outside of his jurisdiction. He was outside of Doraville.
I just want to make sure for purposes of summary judgment, we understand what facts we're actually relying on. If there's some evidence that the lights were on, then for purposes of summary judgment.
His lights were on. Okay. There's no question. I'm not disputing that his lights were on.
So,
but no
outside of jurisdiction and all that kind of stuff really wouldn't matter at that point then.
Correct. But no witness says I changed lanes in response to any blue lights or that was the proximate cause of the collision. In
so
fact,
the affidavits just assume that the affidavits assume that people change lanes, and you assume that they change lanes because of the lights?
No, the two witnesses who were still available, the guy who actually struck Mr. Stevenson's vehicle, said, I never saw any flashing lights of any police vehicle. Arnold Sloan, who was involved in the collision, said, I never saw any flashing lights of any vehicle. The guy who allegedly changed lanes, and Mr. Zastro struck Mr. Stevenson, didn't stop. Nobody found him. So there's no evidence. It's speculation as to whether anyone changed lanes in response to the officer's presence. It seems to me that an officer who's outside of his jurisdiction, who is traveling up an entrance ramp, and he sees a stalled vehicle in the middle of the roadway, to say that he should not stop and turn on his blue lights and assess the situation before deciding whether to pull out into this expressway at 10 o'clock at night in the rain with cars doing 80 miles an hour is negligence, just belies logic in my mind.
If it was really congested, by the way, they probably weren't doing 80 miles an hour.
Well,
but let me ask you, you said there's no evidence that anybody actually moved over in response to the lights. If there was such evidence, if an officer, just like a private individual, put his car in a place that diverted other people, creating a dangerous situation that results in injury, wouldn't that be active negligence?
It potentially could be active negligence, but I would submit to you that in this record, it's read Judge Purdom's offer.
And you can't even infer from the totality of the evidence that anyone moved over and that was a cause of the accident? That anyone moved over in response to the placement of...
You'll have to find that was a negligent act. And how can you say that a police officer, he didn't have to stop. He was outside of his jurisdiction.
But again, whether he has to stop is more the passive negligence.
Right.
But having stopped in a particular location if he does something affirmatively by stopping, that if I did it affirmatively by stopping, I would be liable. You're not creating any special duty for law enforcement. You're applying you're applying the usual rules of tort.
Well, let me address one issue first. There is no evidence that he was in the emergency lane. The only evidence is that he was on the entrance ramp. Travis Bowie prepared a police report that said, at the time I arrived, which was post-incident, this is where Mahar's car was. Mahar testified unequivocally that after the collision happened, he pulled onto the entrance ramp and helped direct traffic. In fact, he was the first person to get to Mr. Stevenson to render aid to him. So he was on the entrance ramp. Why would any police officer, if you're going to say maybe he had some duty to stop and render aid, would you expect a police officer to just stop his car and not turn on his blue lights? He didn't get out into traffic. Now, if as the plaintiff suggested, he should have driven his car out onto the expressway, then he's endangering everybody that is on the roadway.
But it seems to me your analysis depends on us making an ultimate decision as to what was negligent or not, as opposed to where there's a claim stated that could survive summary judgment. So once he stopped, whenever we ask the question, is it possible for there to claim to be was it possible for there to be a claim of negligence? It sounds like your answer is there is no negligence, not whether it's possible.
I believe a reasonable jury could ever conclude that a police officer, when he sees a roadway hazard, he didn't know if anybody was in the car. Stevenson didn't know if the police officer was in the car. He reported it as a road hazard. It could have been debris on the roadway. It could have been that Stevenson had already left his car and there's a car on the roadway. So to say, well, he stopped his car and he turned on his blue lights while he called for assistance and assessed the situation as negligence, it seems to me that that's not.
But there's a question of, it's not whether he stopped the car, it's where and what he did. And if I, driving up behind let's say it's a 2-lane road, 2 lanes, one coming toward me, and there's a car stalled in the other lane, and I stop on the emergency lane directly, instead of pulling past that car, I stop where anyone, and put on my hazard so that anyone seeing me and getting out of my way is going to run into the other car. That would be negligence, right?
I don't believe in this context it would be negligence.
No, I'm just saying that, my hypothetical, that would be negligence, right?
I don't believe it would. Well, why are you stopping the car? To render assistance?
I'm stopping to be a good guy, but by the way I stop, I've created a hazard that was worse than the one.
He wasn't on the expressway now. He's in the emergency lane. I just don't believe that that can be a case that goes to a jury, and as you point out, if this case goes to a jury, every case will go to a jury.
Not on an active negligence. If it's an active negligence theory.
The plaintiff's lawyers will always make it active negligence. Should he have driven on? He was not on the roadway. There's no evidence to support that.
If the question is should he have driven on, that's a question of passive negligence. He didn't do anything to make the situation worse.
I don't believe he did anything to make the situation worse.
I know you don't believe it. The question is there any reasonable inference from the evidence construed as much as possible against you that was a negligent act to park where he did and put on his blue lights?
I really can't concede that point, Your Honor. Right. I just don't believe that in the context of police in particular, that stopping to render aid on an emergency lane or on an entrance ramp by engaging your lights, calling into dispatch, telling them that you're there, saying, I'm going to try to help this guy. And
you're saying he was in the emergency lane. Is there any evidence at all to support the notion that he was in the roadway?
None. They don't even allege that he was in the roadway. They allege that.
I thought I heard him say that he was in the first lane.
No, absolutely not. And
that little chart that we saw, but there's no evidence?
He had him in the emergency lane. That's all. Their argument is he wasn't on the entrance ramp. His testimony is, I turned around, I'm coming up the entrance ramp, I see something in the roadway, I call dispatch, stop, turn on my lights, and I say, I see a stalled car in the roadway, I'm going to try to get over to it. 41 seconds later, He says, I can't get over to it safely.
That's what he says, but someone else says 5 minutes later. So
Nobody says that, Your Honor. It's just a misrepresentation of the facts. The plaintiff himself was deposed and said on 3 separate occasions, I've quoted these in my brief, 3 separate occasions, how long did you stay in the car? 2 to 3 minutes. How do you know that? I looked at my cell telephone records and confirmed it.
what did his brother say?
His brother submitted an affidavit, no cell telephone records, that said, I was on the phone with him for 5 minutes.
Okay. So there is evidence in the record that it was 5 minutes. You may not like that evidence. You may think it's not credible, but we're on summary judgment.
The plaintiff himself says it's 2 to 3 minutes.
So what? The evidence is in dispute.
I just respectfully disagree with that type of analysis. When the plaintiff himself says it's 2 to 3 minutes, the dispatch tape confirms the exact time sequence. But getting there, you're talking about whether he had a duty, whether it was 5 minutes or 20 minutes, whether he had a duty to put his car out into the roadway in front of oncoming traffic, which would violate his duty to the public in general, in my opinion. And there is no question, there's 2 aspects to this, I guess, is what I'm trying to respond to. One is this active negligence theory. I don't believe there's evidence of active negligence, even an inference of active negligence. And I think it would be a horrendous rule to suggest that a police officer who stops to consider rendering aid under these circumstances, who simply turns on his lights and calls dispatch, whether he's in the emergency lane or on the entrance ramp, is a negligent act, particularly where there's no evidence that anybody responded to those lights on the roadway. There is
Counsel,
no... Yes?
We have the record before us. We'll get to the bottom of,
Right.
of what the record actually shows. But assume for a moment,
Okay.
you may say this is entirely hypothetical.
Right.
But assume for a moment that the cars were on the roadway, as Mr. Howard suggested, that Officer Mahar was in lane 1 and Mr. Stevenson was in lane 3. Would you concede that if that's what the record shows, that it was foreseeable that Officer Mahar's placement of his car in lane 1 would cause traffic to divert into lanes 2 and 3, and that therefore increased the danger to Mr. Stevenson?
Let me answer that 2 ways. First of all, I don't believe Mr. Howard is going to suggest to you that he was in lane 1. He was
That's what he said in his entire presentation, that he's in lane 1. His diagram showed that he was in lane 1.
Officer Bowie's report said he was in the emergency lane. That's the only argument. If you look in the record, you'll see that's the argument that's been made all along.
But my hypothetical assumed he was in lane 1.
Okay.
Assume for a moment he was in lane 1.
If you assume for a moment that he was in lane 1, maybe you could make out an argument that says he caused the accident through his negligence. Now, I will tell you this also. If you look at your previous court decisions here, Fletcher's dissent in Hamilton versus Kennan, as well as Sears-Collins' opinion in Roe versus Coffey, the public duty doctrine, many people argue, should extend to negligence. And Justice Fletcher even argued that it should extend to gross negligence. And the statute that was adopted by the legislature, 315-7, which talks about rendering aid to someone who is in danger, a law enforcement officer shall not be liable at law for any action or any actions done while performing any duty at the scene of an emergency except for gross negligence, willful or wanton misconduct. Now, that does reference police officers, but to me...
An immunity statute?
It's not an immunity... Well, in a sense, you could consider it an immunity statute. I consider immunity sovereign immunity and official function immunity under the Constitution. But it is a statute that provides a defense, and it says the standard for law enforcement activity when rendering any type of action in connection with an emergency is gross negligence. And even though it says law enforcement officer, to me it evinces an intent by the legislature that when police are rendering aid to persons, the standard should be gross negligence and not simple negligence. Let's posit for a second that Stevenson had run to safety and that this was just a stalled vehicle. Where are you going to place the duty on the officer here? How about the people coming down the roadway? Let's suppose it was a piece of debris. And what is Stevenson's argument? He says, but for the police car, I would have run to safety 5 minutes earlier. Well, when he got out of his car, he got hit. How can you possibly say that this reliance of him staying in the car, whether it's 2 minutes, 3 minutes, or 5 minutes, he wasn't injured sitting in the car. He was injured when he got out of the car. He's on a heavily trafficked intersection at 10 o'clock at night in the rain. It's pure speculation to say, because I thought this might be a police officer, and because I thought he might be there to help me, and because I sat in my car for 5 minutes, I was injured. When in fact, if he wasn't there, I would have gotten out of my car and tried to run across 3 lanes of traffic. Who's to say he would not have been injured there? It just seems to me that, I thought that the question presented was really...
No, that's not a duty argument. That's a proximate cause argument. And we're not here on proximate cause.
Well, the question presented to me by the court was whether the public duty doctrine applies under the circumstances of this case.
Which is solely directed to the duty part of a tort, not to proximate cause.
And I just don't believe, and you know, maybe Mr. Howard will prove me wrong, but I can guarantee you this was argued twice before Judge Purdom and in the Court of Appeals, and at no time was any argument made that by the plaintiff that he was in the first lane of the expressway. He was in the emergency lane, according to them. According to him, he was on the entrance ramp, and there really is no contrary testimony on that.
They can settle that by putting that graphic back up as soon as he gets up to argue again.
Okay. That's really all I have, unless the court has any other questions.
Thank you, counsel.
Thanks.
Your Honors, obviously there's something we need to get straight right now, and that's the position of the vehicle. This is a diagram I prepared, but just so you don't think I made it out of whole cloth, here's the accident report, which is attached to Officer Bowie's affidavit. As you can see, this lane here is the emergency lane. W is Officer Mahar's vehicle, which is clearly in the first lane of travel. And Officer...
Now, is that an entrance ramp?
No, Your Honor.
I know you said that he had said that he didn't cross over because there was a grassy patch.
Yes.
But you're contending that that first lane was not an entrance ramp either?
Yes, Your Honor, and I'll show you Officer Bowie's testimony is the Dorville police vehicle was not on an entrance ramp, and there was no gore area or median or grass separating the Dorville police vehicle from the interstate. That's the testimony in the case from Officer Bowie. And also, Your Honors, I mean, every other witness in this case has placed this a quarter mile down from the
Right, a
entrance
quarter mile
ramp.
up, but the question about Officer Bowie, as I heard it, was he's only saying where the officer was when he responded. Is it clear that the officer didn't move his vehicle between the time of the accident and the time that Officer Bowie got there?
Officer Mahar says that he did move his vehicle. Officer Bowie says that I arrived at the scene, interviewed the witnesses, figured...
How long after the accident did he arrive?
I don't know the answer to that, Your Honor. However, he did say he interviewed the witnesses, arrived there, and that he determined that the positions of the vehicles on his accident report were what the witnesses said, and he even talked to Officer Mahar as well. Also...
Is that admissible evidence, or is that more hearsay? I mean, can we consider that for purposes of summary judgment?
I think you can, Your Honor. I mean, this is an officer who has experience in...
Or is it hearsay?
Well, I don't know if under the new evidence code the incident report itself is hearsay, but we've also attached the affidavit of Officer Bowie, who has testified that I interviewed everybody, including Officer Mahar, so that might be an admission against interest. Also, there was a question, I think Mr. Gray said that there was a misrepresentation of fact about the 5-minute period. Here is the affidavit of Kevin Gale, who says he was talking to his brother and he was stalled on 285, and I stayed on the phone with him for several minutes. I estimate at least 5 minutes while he told me what was happening. He actually then goes on to say that the phone dropped and my brother got back on the phone with me for another minute. So that actually even adds time. But I wanted to be very clear that I'm not sewing this out of whole cloth. These are facts that are in the record.
And what about, is there any witness who says that any vehicle saw the lights and moved, or is that just an inference?
That's an inference, Your Honor, but we think it's a reasonable inference, and here's the graphic. These are the two drivers here who we got affidavits from. They said they couldn't see the blue lights, but Mr. Zastro unequivocally testified that a vehicle pulled out of the first lane of traffic into the second lane of traffic right before the incident. I think it's pretty reasonable to assume that either this vehicle saw the blue lights or he saw a vehicle right in front of him in his own lane of travel and had to move
Counsel,
over.
let me ask you one more question. When the city moved for summary judgment, did it move only on grounds of duty, or did it also move on grounds of proximate cause?
It moved on grounds of proximate cause as well, and we have raised the issue of spoliation of evidence, and also we believe that the court erred because of this vehicle pulling out of the lanes. Thank you.
All right, this court will stand recessed until 2 p.m.